Good morning. Happy Monday. You hear a lot in these auditor videos about the magical 20-minute rule. You can only be detained for 20 minutes, or sometimes you hear it's 15 minutes. Clock's ticking. You got to let me go. Clock's ticking. Where did that come from? Well, you always hear the sovereign citizen style auditors say things like, oh, the Supreme Court says. Supreme Court says, Supreme Court says. Well, U.S. v. Sharp, the Supreme Court expressly said that there is no 20-minute rule. Expressly. Now, your state may have implemented some sort of a time limit, but it wouldn't be the Supreme Court. So maybe you should figure that out. U.S. v. Sharp, a DEA agent was investigating a suspected drug trafficking area. He sees two vehicles approaching a camper, well, a truck with a camper on it, a camper shell, and another vehicle, just a regular car, following behind him. The DEA agent in his unmarked vehicle, as a federal law enforcement officer, doesn't do traffic stops for speeding and things like that. That is not his jurisdiction. But he sees him, and he, number one, assumes that the camper is overloaded. Ooh, that's suspicious, right? Somebody going camping, having a bunch of stuff in their camper. Suspicious. Camper also has quilted curtains covering all the windows. Quilted curtains on a camper. Suspicious. And the other car that's behind it is obviously with it. It's obviously smoking in the bandit time, and they're obviously smuggling drugs. Duh. So the DEA agent follows them and notes that they immediately speed up as soon as he joins the caravan. I call bullshit. I suspect that they were speeding the entire time, because that's what people do. People exceed the speed limit. He was very careful not to say how much they were speeding by, but it wasn't enough to attract the attention of any of the local police. They cross from North Carolina into South Carolina, and then he effectuates a stop. He pulls over, or he activates his lights on his unmarked car, and the driver of the car pulls over. So he stops with the driver of the car, radios ahead, has a local police or state troopers or somebody pull over the camper. So he leaves the car after they get the camper detained. He goes to the camper. They search the camper. This is all in reasonable suspicion, by the way, kids. This is all an investigatory stop. I just want to make that clear. They search the vehicle on reasonable suspicion. He goes there. He confirms his suspicion that it's overloaded. Then he enters the camper portion of it, removes a bale. There are baled things in there. And he smells the marijuanas. It's marijuanas, kids. And he opened one of the bales, and chemical tests confirmed it was marijuana. This whole thing took over an hour, I think, for the original car that was detained. They wanted to suppress the evidence of the marijuana. The Supreme Court said no. The DEA agent was diligently conducting his investigation, and they're just not going to put any time limits on it. And the search was also valid because, you got to balance what they're looking for with the reasonableness of the search, etc. And so it was all good in the hood. Now, your mileage may vary on whether that's what it should be, but that's what the Supreme Court said. So 20-minute rule expressly kicked down by the Supreme Court. They said, no, you cannot have a 20-minute rule. So there you go. There you go, kids. The Supreme Court did not say you get 20 minutes to be detained, or whatever time limit auditors think. It is as much time as the officer needs to complete his investigation, as long as he's doing it diligently. And it's not for you to determine whether it's diligently. It's for the courts to determine whether it's diligently. So now that we have talked about things that are, I think, of value to the community, I'm going to go back to picking on my favorite sovereign citizen. After I pointed him to 28 USC, the Enabling Judiciary Act, it's the all the various laws and statutes that deal with the judicial court or the federal judiciary. He noted that there was a statute in there that gave the federal courts the power to hear all cases and controversies arising under the laws of the United States, treaties, and the Constitution. See, he says, that's the one that gives you a cause of action. That's the one that gives you a means to sue under. And when you go into federal rules of civil procedure in law school, it's a whole year course. And so I'm going to give you the super Cliff Notes version of why he's retarded. And you're just going to have to deal with the super Cliff Notes version because, number one, I probably couldn't give you anything beyond the super Cliff Notes version because this is the kind of stuff that you consult a practice guide before you file your suit. This is the kind of stuff where you look up cases before you jump in, and you don't just know it off the top of your head unless you deal with this kind of stuff all the time. But you need basically three things. The court has to have the power to hear it. That's the jurisdiction of the court. That's subject matter jurisdiction. And that's what that statute is talking about, cases and controversies. It's in Article 3, and for whatever reason, Congress had to codify it when they created the Article 3 courts. They gave the Article 3 courts the power to hear everything that the Constitution, the limits of the Constitution, gave them the power to give those Article 3 courts. So that's just jurisdiction. They have the jurisdiction to hear it. But there's two other things that you need to satisfy. Number one is you have to have standing. Standing is complicated as fuck. But the super Cliff Notes version is you have to be injured or about to be injured. That injury has to be caused by the person you're suing. And there has to be some way that the courts can actually remedy that injury. And for a super basic example, it's like the post office. If you want to go film at the post office and you know that they have the restriction against filming, then, oh boy, he's gonna throw up. All right, we've got that taken care of. So if you want to film in a post office, you know that they have a regulation saying you can't film, so you can sue for declaratory or injunctive relief. The harm would be a future harm. You would obviously be subject to the penalties associated with violating that particular regulation. It would be proximally caused by that regulation, so that's not a problem. And the court could remedy that situation simply by saying that regulation is unconstitutional as applied or as written. So that's within the power of the court, and you have the standing. You would have the standing to do it. But you need a cause of action, and the only implied cause of action, again, the only implied cause of action that I'm aware of is the Bivens. And the court said, well, you know, we already had the power to give declaratory relief, so we're going to extend it, and they did extend it. Apparently, they also extended it to Eighth Amendment, but they didn't extend it beyond government actors in the Eighth Amendment. But it's Fourth, Fifth, or Eighth Amendment. It's suing people acting under the color of federal statute. So it's kind of an analog to the 1983. And the big differences are there's no Manel claims. You can't sue the agency. You could just sue the person. And it has to be like It can't be an individual. So the Eighth Amendment one that got shot down that I remembered was where they tried to sue a prison, a privately owned prison that was housing federal prisoners. And the court said, no, there's a state law remedy for that. Go after them on the state law remedy. So again, it's one of these things where this sovereign citizen guy thinks he understands things that he doesn't understand, and he gets pieces and he tries to put them together. But here's like reality that kind of comes slapping around you. There's a reason why there are all these statutes that give you, like the Federal Tort Claims Act. I mean, there's a reason for these statutes. If you could just sue under common law, if you could just sue under the Constitution, I'm suing you for $10 million for violating my First Amendment right. If you could do that, then Congress wouldn't need to have passed all those statutes. But they did, and they do. And there's a reason why you know what a 1983 lawsuit is. It's because you need that to get around sovereign immunity for states and municipalities. You need it. Or else your suit goes nowhere unless the state itself has given you a cause of action to sue. And one other thing I want to point out. Well, there's two other things I want to point out. Number one is I hearted a guy who was citing North Carolina case law, and he said, North Carolina, you can't get pulled over for just doing a U-turn. And he cited North Carolina case law, and I didn't read the case, but I liked it just because I like it when people cite cases, and it seemed like a reasonable analysis, and I don't care enough. But hey, you know what? He did some work, and so I hearted it because I like it when people do that, when they actually look up case law. And then my favorite sovcit comes behind him and says, that's what I've been trying to say this whole time. And that's what I've been trying to say this whole time. This other guy was quoting North Carolina statute, not a Georgia statute, or a North Carolina case, not a Georgia case. So North Carolina and Georgia are different, and they have different laws and different interpretations. I'm going to link, if you don't believe me, I mean, I've already given you actual Georgia case law that I read to you on a video saying that, yes, it is evasive action, making U-turns and things like that is evidence that the cops can rely on to be the articulable fact for their reasonable suspicion. But I'll also link a DUI attorney out of Georgia, his website. There's more. I'm not going to link all of them, but there's more. I'll link one that shows that yes, just flipping a U-turn can be enough if it's suspicious enough. And if you look at what the guy did in Earl's video, it was a 2-lane road, 1 lane in each direction on the country. He gets just close enough to see it. He turns into a driveway, backs out to go the opposite direction. He does a 3-point turn, essentially, is what I'm trying to say. He does a 3-point turn on a country road, going nowhere. I mean, it's Georgia, so really, where can you go? But yeah, that was suspicious. And it's enough just to make a U-turn suspicious. If you're turning into an apartment complex, not suspicious. If you're flipping a U-turn in the middle of a country road, that's suspicious. And I think that was it. Yeah, that'll be it for today. All right, guys, thanks for watching. Have a great day.